My name is Chu Machinye, and I am your family lawyer. Somebody who is the beneficiary of an insurance is eager for the person who took out insurance to go quickly so that he could get the money. Could be your wife, could be your child. So tread carefully on this. We can't conclude this aspect of this podcast without talking about shareholders' agreements. In family businesses with multiple shareholders, these agreements specify how shares are transferred upon death. They offer buyout options to avoid conflict. They prevent outsider intrusion into family control. Now, it is not also true to say that it's only for these purposes. Shareholders' agreements can apply to big companies, and they're often used to determine who gets what, who can transfer what, and how things generally would go regarding shareholding. These contracts among shareholders govern how a company is run and what happens when a shareholder dies. Of course, the law governing this is the Companies and Allied Matters Act. And you could use it to include buy-sell clauses, board appointment rights, share valuation methods, and share transfer means and methods. It helps to prevent power struggles and avoid needless litigation regarding shares. There are a few tricky situations which we have a duty to bring to your attention. One of them is when you need to protect yourself from your businesses and wealth from previous marriages or stepchildren. The best way to do this, use trusts and holding companies and ensure to separate your wealth from family wealth, and be sure that if you intend for specific children to benefit, it is clearly done. And in such cases, avoid joint bank accounts unless survivorship is intended. If you want to be certain that family is different from business, one of the things you should avoid is joint bank accounts unless survivorship is intended. It's also tricky when you need to guard against hostile boards or partners. This happens quite often. And the best way to avoid this is to use shareholders' agreements, use voting trusts and family constitutions to be certain that issues are clearly delineated. And you can appoint directors you trust and create successor mandates in company filings, just to be sure that you're on the safe side. Next is a thorny question of how you hide and make discrete transfers regarding your shares. You can use blind trusts. You can use nominee directors, trusted corporate entities, or just simple proxies. Bear in mind, though, that asset hiding has limits. If challenged in the course of a divorce, it has tax complications, and when crime is involved, it could become really messy. Also, regarding gifts, inter vivor, and offshore accounts, bear in mind that asset hiding has limits, and if challenged during the course of a divorce, could be very messy. It could have tax implications and sometimes criminal connotation. Now, when it comes to gifts, inter vivor, and offshore accounts, trusts can be used, but documentation is key. In all of this, what you need to do is to talk to a competent solicitor for guidance or visit our website for more information if you need to hide an asset. If you're a politician or politically exposed person and you're thinking that you need to hide some assets, then you may talk to us, but we will guide you only within the ambits of the law. There are challenges often in family business succession. The road to a smooth transition is riddled with mines, land mines, that is. The challenges that are legion include that many business owners do not leave wills or create trusts. Their assets are often registered in personal names, not in corporate titles. And oftentimes there is lack of clarity, which leads to multiple probate applications, caveats, and litigation when they pass on. In some cases, second or third wives surface after death with their children in tow claiming ownership. There is also the issue of sibling rivalry, which often becomes like war over access to business assets when the big man or the big woman passes. And distrust between professional managers and family heirs can also lead to issues of trouble, quarrels, and court litigations. Sometimes there are religious and cultural issues which challenge succession efforts. Some faiths view making a will as inviting death. Generally, Nigerians think this way. In Islamic succession, strict quotas for heirs often conflict with the founder's vision. In some cultures, daughters are not seen as successors, despite legal rights guaranteed by the Constitution. Some of these issues inhibit effective succession planning. It is good always to be guided by a family lawyer. You may wonder why you need to be this educated about business succession. It is simply because it is very rampant to see businesses collapse after the original owner's demise. From the outside, you have no idea of the kind of ruffle that often go on between family members after the big man or the big woman's death. And these eventually culminate in the failure of the once thriving enterprises. But why, you may ask? The answer could arise from any of the following scenarios. So I will just show you in little snippets of how these issues arise. In some cases, founders and business owners often centralize decision making. They hold information regarding their wealth and business dealings tightly to their chests, and sometimes they hold it into their grave. In consequence, acrimony, distrust, needless tension arise in the family when he suddenly drops dead. A lot of the wealth of politicians, portfolio businessmen, and civil or public servants are lost to bankers and associates who will house these assets without proper documentation, and sometimes, believe me, outside the knowledge of family members. If you are doing these kind of things, please talk to a family lawyer. If you don't want your family to know exactly whilst you are alive, let your family lawyer know, and let there be proper documentation so that when you go home, your businesses and money can be beneficial to your family members. Another cause of these kind of problems is where successors lack interest, where they are not trained, or where they lack the discipline to take over the businesses built by their forebears. This is a possible cause of rift and attrition in families. In the past 2 decades particularly, most Nigerians who could afford it have sent their children overseas for better education. Whilst there, most of them get acculturated, that is, they imbibe the traditions and customs of foreign lands. In consequence, these potential heirs lose interest in partaking in the family businesses for which they were ostensibly being groomed by their parents, who spent so much money to send them abroad, acquire superior knowledge, and come and help me to grow this business. Many small and medium-scale businesses are grown by illiterate or hardly educated businessmen and women who adopt legally informal business models without defined systems and structures. They often leave succession to verbal promises made to their family members, which is not written down, and this often breeds dispute and business failure when they pass on. Daunting as these issues may sound, they are not insurmountable. They are things actually simple to deal with if the key stakeholders are engaged by business owners. For instance, you must be talking to your lawyer frequently. The lawyers will provide legal structure. They will draft a will for you. They will draft trust, create trusts that are worthy to be called trusts. They will help you in incorporation of holding companies. They will mediate in family disputes and translate your visions into enforceable documents so that when you are gone, they speak for you. Banks and financial institutions also play a great role if you make use of them effectively. They can help with execution of mandates and transfer authorities. They help to manage trust funds and succession portfolios. They could act as neutral custodians of your assets while disputes are resolved. There is also the use of family members. So they need to be prepared through mentorship, shadow leadership, and transparency, and effective communication. Therefore, they should participate early in vision sharing and building, and dispute resolution and planning. This should be an ongoing process, not left for when the patriarch has suffered a stroke or a heart attack, or when he fears that he's about to die. Stitch in time, they say, saves 9. It is time to walk you through what the courts have to say about business succession planning and how families have either suffered or benefited from planning or failing to plan. A certain Mr. Gochuku died. He owned a thriving transportation company, but died without making a will. He had 2 wives. He had 10 children. He had no succession plan. When the matter went to the court, equitable distribution was what the court emphasized and resolved the issues for the family. But in the intervening period, the company had lost contracts, had lost loyal drivers and staff. And by the time the judgment came, the business was a shadow of itself. The lesson to be learned from this is that you could lose a lot if you don't plan your succession. The courts may intervene and do justice, like in this case. But in the intervening period, your company might lose value, assets will depreciate, and at the end of the day, when justice is done on paper, there may be no company left to inherit. The next story involves the Akonde family. It's a matter that was decided in 2001. The founder of a company has structured his company through a trust and family holding company. One of his children challenged the plan, alleging exclusion. The trust was upheld. The court held that once the intent is clear and not illegal, the founder's structure must be respected. The lesson from this is that strategic planning, backed by documentation, withstands emotional issues and challenges in a family. You know, I'm aware that when I was discussing the legal issues, it may have appeared boring. So I'm going to use a few more stories to bring this to clarity, making sure that everyone who is listening to me understands what we are talking about. So let's bring it to life even more with a few more stories. In the next story, Chief Akinola intended to give everything he had to his son. He was a wealthy patriarch. He made a will, left all his property in quotes to his first son in the will. But he forgot to mention specifically that he had a 60% stake in a private company. The matter went to the court, and the court held that the shares that were not specifically bequeathed to the son will not be part of the will. It will form part of the man's intestate estate, which is estate that is not governed by a will. And so the laws of intestacy will apply to the shares that are in question. In yet another court scenario, Alhaji Bashiru Akonde established a real estate empire across Lagos. Before his death, he spoke about setting up a family trust. He even signed a trust deed, but he never transferred his properties or company shares into that trust. When he died, his trustees tried to claim control of his estate, but the children contested this, arguing that the trust was never funded. You know what the court said? The court agreed with the children, and the judge said that the trust must be complete. In other words, there must be property put into that trust or money put into it. If it is empty, it is simply a vacant trust. You cannot use it to transfer anything that was not put into it. It's garbage in, garbage out. And this situation led to a lot of litigation within the family. And the lesson we must learn is that intentions are not enough. You must make effective use of your lawyers to ensure that your intentions are properly documented and everything is done to conclusion. All that is well should end well. The next story and the last one we will tell you today will help us to close on a good note, on a happy note. In spite of the absence of a succession plan, it ended well for the Odutola family. Chief Timothy Odutola, the founder and majority shareholder of a company, died suddenly. His shares were held in a private company, but he had no succession plan. None was documented. Perhaps none was even prepared or thought of. Of course, disputes arose regarding the control and management of the company between the family, the widow, and children, and the board members. The children fought, the board members fought back. The court waded in and allowed the family access to the company, access and control actually. But the succession battle was messy and expensive. The lesson to be drawn from this is obvious. Use holding companies. Make clear succession plans and rules and transfer your shares if need be. Do so and do so on time. Do so tidily. Do it properly. We're almost done with today's episode, but let me give you my final word on this. Business succession is not a matter of if, but when. And the time to do the planning is now, not tomorrow. Because without a plan, everything you build could collapse when you are gone. With a succession plan, you can preserve your legacy, protect your family, and inspire generations. Wealth transfer isn't just about money, it's about legacy, it's about peace of mind and control. With the right tools, from trusts to wills, from holding companies to survivorship deeds, you can guard your wealth and pass it on wisely and smoothly. It's time for me to go, but before I do, let me thank you immensely for joining me on today's episode of Your Family Lawyer. Be sure to subscribe, like, and share this episode to your family members and friends or business associates. In the meantime, stay informed and be empowered, and please, by all means, be good to your family. My name is Chu Machinye, and I am your family lawyer.